1509 is more Executive Order 1509 is more restrictive than the Ethics Act and does not allow for the acceptance of any gifts in your capacity as a public university employee, regardless of value, unless the gift is specifically identified as an exception. Additionally, EO 1509 restricts meal acceptance to only those meals that are of de minimis value and are served at a business meeting or reception attended by the employee as part of their official duties. Select the Exceptions tab to continue. Earlier, it was mentioned gifts from prohibited sources are not allowed unless one of the exceptions within the Ethics Act is met. When one of the exceptions is met, a university employee may accept the gift without further action. There are 12 exceptions allowing employees to solicit or accept gifts from prohibited sources. The 9 most commonly occurring exceptions in the university environment are listed here. A few key gift areas in the Ethics Act are honoraria, the educational materials and missions exception, receiving gifts, and soliciting gifts. We'll go into more detail about each of these topics now, starting with honoraria. Honoraria, i.e. payment for a service such as making a presentation, typically paid to a faculty member, are considered gifts and are not exceptions to the gift ban. Select each tab to learn more about what the Ethics Act has to say about honoraria. The Educational Materials and Missions Exception, or EMM exception, addresses those gifts related to official university business, such as travel, conferences, and speaking engagements, where a prohibited source is covering some or all of the related expenses. Typical expenses allowable under this exception include, but are not limited to, lodging, conference fees, meals, and transportation. The EMM exception is further clarified through Administrative Rule 1620.700 and Executive Order 1509. Per EO 1509, approval for the EMM exception must be granted by the Executive Director of the EEC and must be requested in advance of the activity. The Governor's Office provided further clarification, allowing the EEC to delegate the approval authority to the University Ethics Officer. The University of Illinois System, Southern Illinois University System, Illinois State University, and Northern Illinois University sought and received this delegation, allowing for internal approval of EMM-related gifts. If an unexpected gift from a prohibited source shows up in the mail to your office, taking one of these actions promptly will allow you to remain compliant with the law. Select each card to continue. Donate the gift itself to a 501c3 charitable organization. It is considered good business practice to maintain a copy of the donation receipt, canceled check, or other form of support in the event compliance is ever questioned. Much of our focus when discussing gifts is on the receipt of gifts. However, the gift ban also restricts us from soliciting or requesting gifts from prohibited sources. This prohibition extends to include our immediate family members living in our households. Within each state agency and public university, there are also additional policies and guidelines that may further restrict certain events or activities. The stricter of the two must be followed. It's important to be vigilant of internal policies that may be unique to your unit or university, so you can avoid violating them unintentionally. Sometimes, even the best of intentions can have consequences. When you're ready, select Next to move on to some practical examples. There are several possible examples of gifts in a university. There are several possible examples of gifts in a university setting. It is important to refer back to the exceptions to ensure one or more apply when accepting a gift of any sort. Consider the expectations when selecting responses to these scenarios. There are several possible examples of misuse of university resources is a violation of the Ethics Act. University employees must always be aware of the ways university resources are used to ensure there is not misconduct, whether intentional or unintentional. Pay attention to your environment and be aware of things that don't seem right. In general, don't misuse university property and report any believed misuse of resources. Select the Next button to take a look at two examples of misuse of university resources. As you may recall, during the COVID-19 pandemic, there was significant media coverage regarding the shortage of personal protective equipment, PPE, in hospitals. N95 face masks were an especially scarce item, and many hospital workers were reportedly having to reuse their masks and other forms of PPE to combat the shortage. Select each tab to learn more. View all tabs to continue. A public university employee in Pittsburgh stole close to 14,000 pieces of PPE, mainly face masks and respirator masks, from the university and sold them online. This individual profited nearly $19,000 and was later indicted by a federal grand jury, terminated after 7 years of university employment, and was pursued for reimbursement of the stolen university property. In this case, several findings were present. To begin, it was a misuse of university resources and theft to misappropriate university property for non-business purposes. Stealing and subsequently selling the equipment online was a violation of university policy, in addition to being illegal. This employee also failed to fulfill his responsibilities to keep the faculty, staff, and students of the university safe by ensuring the university maintained an adequate supply of protective equipment, especially considering the nationwide shortage. A university resident advisor posted some storage shelving in an online classified advertisement sales website. Since the advisor lives in the campus dormitories, the photos posted depicted a storage closet and the background that was recognized as an area in a university building which another employee saw while browsing the sales. The employee who saw the post and recognized it was taken in a university building was concerned the advisor was selling university property and contacted the university ethics officer. When questioned, the resident advisor was able to provide proof of purchase and clarify the pictures had been taken in a university building where they resided, but that the property was privately owned. Though there was no actual misuse of university resources in this scenario, it is important to be cognizant of your surroundings and the appearance of impropriety. Conversely, if you are an employee who believes there has been wrongdoing, it is always best to report that concern so it can be reviewed in accordance with all laws, policies, and procedures. Select your university's logo to find contact information for your university ethics officer. Though there was no actual misuse of university resources in this scenario, it is important to be cognizant of your surroundings and the appearance of impropriety. Conversely, if you are an employee who believes there has been wrongdoing, it is always best to report that concern so it can be reviewed in accordance with all laws, policies, and procedures. While fundraising efforts to support a candidate for elective office may not have any ill intent, the Ethics Act states political contributions cannot be made, accepted, solicited, or offered on state property, which includes university property. The only time contributions can be made on state or university property is when the building or a portion of the building has been privately leased or rented. Then, during the time of that rental, the Ethics Act restrictions would not apply. The prohibited political activities restrictions within the law apply to each of us as university employees. Any activity to benefit a campaign for elective office or a political organization would be considered a prohibited political activity. These restrictions apply when we are on university property, using university resources, including work time and equipment, or acting in our capacity as university employees. Anytime we are working or representing the university, prohibited political activities must be avoided. However, what we choose to do outside of our work time or when using approved leave time is not governed by the Ethics Act. Though you can use uncompensated time, non-work days, and approved vacation time to participate in political activities, it is important you avoid wearing university-issued clothing, such as work uniforms, hats, or name tags, so you do not give any appearance you are representing the position or opinions of the university itself, and so others don't assume you are participating on work time. As employees, we cannot be offered or ourselves promise any form of compensation, money, position, benefits, in exchange for a contribution to a political committee, political party, or other entity that has as one of its purposes the financial support of a candidate for elective office. This is considered a prohibited offer or promise and must be reported to the university ethics officer or the OEIG.
Musst du den ganzen Tag arbeiten?
Warum schläfst du den ganzen Tag? Bist du krank?
Ich schlafe bis Mittag.
Ich schlafe nicht, denn ich habe Kopfschmerzen.
Meine Familie spielt am Wochenende Hockey. Meine Familie spielt am Wochenende Hockey. Meine Familie spielt am Wochenende Hockey.
Ich mache Yoga, aber meine Frau spielt Hockey. Du schläfst bis Mittag, aber ich schlafe nur bis 7. Du schläfst bis Mittag, aber ich schlafe nur bis 7. Du schläfst bis Mittag, aber ich schlafe nur bis 7. Du schläfst bis Mittag, aber ich schlafe nur bis 7. Du schläfst bis Mittag, aber ich schlafe nur bis 7.
Bis wann schläft deine Katze?
Mein Hund schläft den ganzen Tag. Mein Hund schläft den ganzen Tag. Mein Hund schläft den ganzen Tag. Mein Hund schläft den ganzen Tag.
Ich schlafe gut, denn ich mache jeden Tag Yoga.
Ich schlafe am Wochenende nur wenig, schläfst du viel? Ich schlafe am Wochenende nur wenig, schläfst du viel?
Meine Familie spielt am Wochenende Hockey. Meine Familie spielt am Wochenende Hockey.
Mein Hund schläft den ganzen Tag. Mein Hund schläft den ganzen Tag.
Ich schlafe am Wochenende nur wenig, schläfst du viel? Ich schlafe am Wochenende nur wenig, schläfst du viel? Ich schlafe am Wochenende nur wenig, schläfst du viel? Ich schlafe am Wochenende nur wenig, schläfst du viel? Ich schlafe am Wochenende nur wenig, schläfst du viel?
As employees, we cannot be offered or ourselves promise any form of compensation, money, position, benefits, in exchange for a contribution to a political committee, political party, or other entity that has as one of its purposes the financial support of a candidate for elective office. This is considered a prohibited offer or promise and must be reported to the University Ethics Officer or the OEIG. In the prohibited political activities section, we spent quite a bit of time covering restrictions when you are working, otherwise known as being on university time. Each of us is required to report the time we spend on university business each day. All state employees, including university employees, are required to document their time spent on state or university business to the nearest quarter of an hour. Whether you clock in using a time card or participate in positive time reporting, you are required to accurately document your time spent on university business to the nearest quarter hour, which includes reporting time spent away from university business. Check with your unit for the timekeeping requirements for your position. Let's explore a case where employees were falsifying their time and see what happened as a result. Retaliation is very specifically defined in the law as reprimand, discharge, suspension, demotion, denial of promotion or transfer, change in the terms and conditions of employment. It is not retaliation if the employer can demonstrate by clear and convincing evidence the same personnel action would have been taken in the absence of the protected activity. The Ethics Act, the Whistleblower Act, Executive Order 1604, and University Policy protect employees who, in good faith, report or threaten to report an act or omission they believe to be a violation of law, policy, or procedure. Whether you make the report or become involved in an investigation as a result of someone else's report, under both University Policy and the Ethics Act, you are afforded what is known as whistleblower protections. What this means is the university or an employee of the university may not retaliate against you as a direct result of your participation in protected activities. The protections extend to all parties involved in the investigation, regardless of how they became involved. Actions are considered retaliatory only when they are taken in response to a whistleblower's involvement in a protected activity. Protected activities include disclosing or threatening to disclose to a supervisor or a public body any practice, activity, or policy of a state or university employee or state agency or university that the employee reasonably believes is in violation of a law, rule, or regulation. Providing information to or testifying before a public body about any violation of the law, rule, or regulation by any officer, member of the General Assembly, state agency, or other state employee. Or assisting or participating in a proceeding to enforce the Ethics Act. Whether you are the person filing a report, a potential witness, or the person who is the subject of an investigation, as a university employee, you have an obligation to cooperate in OEIG investigations. You must participate in interviews as requested, tell the truth, and not withhold information. Failure to cooperate includes, but is not limited to, intentional omissions and knowing false statements, and is grounds for disciplinary action. As a university employee, if you witness misconduct or have evidence of it, you should report it to the proper authorities. Your responsibility is to report your concerns or observations to someone in a position to take action. You may recall at the beginning of this training, we discussed both internal and external options, which included the University Ethics Officer and the OEIG. University researchers may receive funding through grants funded by U.S. taxpayer dollars, such as a National Science Foundation, NSF grant, or similar, and they are required to disclose all applicable outside funding and potential conflicts of interest. There have been several cases recently related to U.S. faculty members obtaining federal research grants but failing to disclose that they were also receiving other domestic or international funding. Lack of disclosure may result in a federal investigation, indictment on federal counts of fraud and making false statements, repayment of grant funds, and debarment from applying for future research funding. This type of scenario exemplifies an important aspect of the Ethics Act, which requires employees to be truthful and honest in all communications and disclosures. Universities have internal processes requiring employees to disclose outside commitments and interests. In addition, some university employees are also required to complete the state-mandated disclosure forms known as the Statement of Economic Interests and the Supplemental Statement of Economic Interests. The Statement of Economic Interests is a disclosure form required by the Illinois Governmental Ethics Act to be filed with the Office of the Secretary of State. Illinois Executive Order 1509 requires the filing of an additional form, the Supplemental Statement of Economic Interests, with the EEC. Employees meeting any of the listed criteria are required to file these two forms. Those individuals required to file are notified early each spring by the Office of the Secretary of State and the EEC. Both forms must be filed by May 1st, and there are late filing penalties associated with the Statement of Economic Interests. A public officer, employee, or special government agent commits official misconduct when, in their official capacity, they intentionally or recklessly fail to perform a mandatory duty as required by law, knowingly perform an act that is against the law, intentionally perform an act in excess of their lawful authority with intent to obtain personal advantage for themselves or another, or purposefully solicits or knowingly accepts a fee or reward for performance of an illegal act. Official misconduct should be reported to the authorities. Specifically, bribes must be reported to the Illinois State Police, and failure to report may result in possible criminal charges. Illinois procurement laws Illinois procurement laws require university employees to follow specific processes and requirements to protect the integrity of the procurement process. For more information on the reporting process, please contact your university ethics officer. Universities and other agencies who receive state funding have certain restrictions related to public service announcements. Section 520 of the Ethics Act prohibits universities and the like from using the proper name, image, or voice of any executive branch constitutional officer or member of the General Assembly in any advertisements, such as billboards, brochures, or media presentations. While this is not specific to any of us as individual employees, it explains why we don't see images of our politicians on university billboard displays. If during the year preceding departure of state or university employment, the employee participated personally and substantially in awarding of contracts to vendors with a cumulative value totaling $25,000 or more, or the fiscal administration of such contracts, the employee, spouse, or immediate family members living with the employee are prohibited from accepting non-state employment from that vendor for a one-year period immediately following termination of state or university employment. Review each tab to learn more. The revolving door prohibitions apply to all employees. However, only a small portion, known as C-list employees, are absolutely required to seek a determination when leaving university employment. For the majority of us who are not C-list employees, we only need to concern ourselves with seeking a determination if and when we are directly involved in the decision to contract for goods or services over $25,000, or when we are the person responsible for the fiscal administration of that contract. In other words, if you are involved in determining how and when money is spent, approving any change orders on the contract, or other matter related to vendor payment, the prohibitions would also apply to you in this instance. If you are an H or C-list employee, you will be notified of the revolving door prohibitions. Let's talk in a bit more detail about the H and C-list parties. H-list parties are prohibited from accepting employment or receiving compensation or fees for services from certain individuals or entities for a full year after terminating their university employment. C-list parties must go through the determination process to seek approval for post-state or university employment. The determination process through the OEIG is to be completed before accepting the employment offer. If an employee accepts non-state employment in violation of the revolving door prohibitions, they may be subject to significant personal fines. In our next section of training, we will explore another aspect of the Ethics Act, which focuses heavily on harassment and discrimination prevention, and other aspects of the Illinois Human Rights Act. Engaging in sexual harassment is a violation of Section 2102D of the Illinois Human Rights Act. Additionally, universities have their own policies related to sexual harassment and sexual relationships in the workplace. It is important you are aware of and understand the policies guiding you both university-wide and within your unit. The Ethics Act states all persons have a right to work in an environment free from sexual harassment. Additionally, all employees and appointees are prohibited from sexually harassing any person, regardless of their employment relationship or lack thereof. The Illinois Human Rights Act, as well as other laws and university policies, prohibit harassment and discrimination on the basis of someone's actual or perceived membership in one or more of the following protected classes. Select each arrow to learn more. Unlawful discrimination occurs when an employer takes a discriminatory employment action because of an applicant's or employee's actual or perceived membership in a protected class. However, it does not prevent an employer from taking employment action for another reason unrelated to an applicant's or employee's membership in a protected class. So, if you are falsifying time reports or violating policy or the law in some way, and you are pregnant, you can still be disciplined for your violations of law or policy, regardless of being part of a protected class. Select each flashcard to learn more about unlawful discrimination. Unlawful discrimination is defined in detail in Sections 103 of the Illinois Human Rights Act, and is when a person is discriminated against because of their actual or perceived race, citizenship status, color, religion, national origin, ancestry, age, sex, marital status, order of protection status, disability, military status, sexual orientation, pregnancy, unfavorable discharge from military service, and/or work authorization status. Discrimination is considered unlawful if, based on a person's actual or perceived membership in one or more of the protected classes outlined previously, an employer takes action involving recruitment, hiring, promotion, demotion, selection for training or apprenticeship, renewal of employment, discharge, discipline, tenure of terms, privileges, and/or other conditions of employment. The Illinois Human Rights Act also prohibits other discriminatory acts in employment, including prohibiting employees from speaking their native language when unrelated to work duties and certain immigration-related practices, such as an employer using more or different documents than are required under certain federal laws, or refusing to honor documents that on their face appear to be genuine. Imposing conditions that would require an employee to violate a sincerely held religious practice, such as not allowing an employee to wear religious clothing or accessories in the workplace. Failure to offer employees reasonable accommodations related to pregnancy or childbirth, or discrimination based on age in training and apprenticeship programs, such as excluding an employee from a training program because they are nearing retirement. Harassment means any unwelcome conduct on the basis of an individual's actual or perceived race, color, religion, national origin, ancestry, age, sex, marital status, order of protection status, disability, military status, sexual orientation, pregnancy, unfavorable discharge from military service, citizenship status, or work authorization status that has the purpose or effect of substantially interfering with the individual's work performance or creating an intimidating, hostile, or offensive working environment. Harassment is not limited to occurring in the physical location where you perform your job duties. Examples of conduct that could amount to harassment, if based on a person's actual or perceived membership in one or more protected classes, include offensive jokes, slurs, epithets or name-calling, physical assault, threats, intimidation, ridicule or mockery, insults or put-downs, offensive objects or pictures, deliberate touching, leaning over or cornering, offensive looks or gestures, and/or letters, telephone calls, personal emails, texts, or other materials of an offensive nature. Sexual harassment varies from the broader definition of harassment in that it involves any unwelcome sexual advances, requests for sexual favors, or any conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly a term or condition of employment. Submission to or rejection of such conduct is used as the basis of employment decisions, or such conduct has the purpose or effect of substantially interfering with work performance or creating an intimidating, hostile, or offensive working environment. The phrase working environment is not limited to a physical location an employee is assigned to perform his or her duties and does not require an employment relationship. Sexual harassment is essentially any type of harassment that has a sexual nature or undertone. Under the Illinois Human Rights Act, if the university or a university employee becomes aware of harassing behavior and fails to take reasonable corrective measures, the institution may be held responsible for the sexually harassing or harassing behavior of a non-employee, non-managerial employee, or non-supervisory employee. Sexual harassment of or by non-employees, such as contractors and consultants, is also prohibited. There are several types of sexual harassment all employees should understand. These include quid pro quo, hostile work environment, harassing behaviors, and inappropriate electronic harassment. Select each tab to learn more. Any employee who witnesses, is subjected to, or becomes aware of sexual harassment, and/or discrimination should immediately report the incident. That report can be made to the employee's supervisor, your University Office of Access and Equity, University Ethics Officer, the OEIG, and/or the Illinois Department of Human Rights, also known as IDHR. If you choose to make a report to your supervisor may have an obligation to inform the applicable Title IX coordinator or your University Office of Access and Equity. Select each tab to learn more. In addition to the Ethics Act, the Whistleblower Act, Executive Order 1604, and university policy, the Illinois Human Rights Act also protects employees who, in good faith, report or threaten to report an act or omission they believe to be a violation of law, policy, or procedure. If there is retaliation resulting from a report of sexual harassment, or discrimination, the employee has an additional option beyond their supervisor, university ethics officer, or the OAIG of reporting to the IDHR or to file a civil suit. The Illinois Human Rights Act also states it is a civil rights violation to retaliate against a person who opposes that which they reasonably and in good faith believe to be unlawful discrimination or sexual harassment. An example of retaliation includes a supervisor who demotes an employee upon learning the employee reported in good faith the sexually harassing behavior of another coworker. There are serious consequences for engaging in unlawful discrimination, sexual harassment, and harassment, which may include being disciplined or terminated for violating the law or agency policies. Sexual harassment, and unlawful discrimination can also be punishable with fines or penalties imposed by a state or federal agency or court. Any person who violates the Ethics Act's prohibition on sexual harassment may be fined up to $5,000 per offense. Engaging in sexual harassment, unlawful discrimination, and/or retaliation can subject an individual to proceedings before the Illinois Human Rights Commission or state or federal courts. For example, individuals can file a state or federal charge against the person or entity, and if they prevail, they may be entitled to one or more of the following remedies: actual damages for injury or loss, including emotional damages, attorney's fees and costs, back pay, obtaining a cease and desist order, fringe benefits, hiring, reinstatement, promotion, and prejudgment interest. Any person who intentionally makes a false, frivolous, or bad faith allegation, including an allegation of harassment, discrimination, or sexual harassment, or who intentionally obstructs or interferes in an OEIG investigation or report alleging sexual harassment to the OEIG, EEC, or to certain law enforcement agencies or officials, is guilty of a misdemeanor and may be levied a fine of up to $5,000 from the EEC. Thank you for completing your ethics training and harassment and discrimination prevention training, as required by the Ethics Act. As we wrap up today's training, it is important you keep in mind the concepts learned today to help you not only stay compliant with the Ethics Act and other related laws and policies, but also to do your part in promoting a work environment that is free of fraud, waste, abuse, harassment, and other undesirable and damaging behaviors. Select the bullet and then the check mark to certify your completion of this module.